Welcome to Noon Wednesday. I'm Marissa Wojcik, multimedia journalist with Here and Now on PBS Wisconsin. Today is January 12. So over the last year, debate over whether and how to discuss race in classrooms has taken over school board meetings and is threatening to upend college curricula. Now, Republican bills before the Wisconsin State Legislature are seeking to put limits on how race discussions happen in classrooms into law. So, joining me to better understand what this could mean are two professors from the UW Law School. Steph Tai advocates on behalf of the university faculty with UW Profs, and Anuj Desai focuses on the First Amendment and intellectual freedom. And thank you both for the conversation today.
Thank you for having us.
Thanks. Yeah, thanks very much for having us. We're thrilled to be here.
So, to start off, there are two different pieces of legislation. One is for K-12 public and charter schools. The other is targeted at UW system and technical colleges. They both say that instruction or training is prohibited to discuss, quote, that one sex or race is inherently superior to another sex or race, and that by virtue of the individual's race or sex bears responsibility for the acts committed in the past by other individuals of the same race or sex. So that's a kind of meaty statement. Anuj, can you kind of explain to us what that is saying and why, in your mind, this is a freedom of speech issue?
Yeah, well, let me just start by thank you for raising these issues before the public, and I just wanted to thank the audience for showing interest in these issues. So the first thing I guess I would say is, so the bills are framed in a way that prohibits allowing teachers to teach race or sex stereotyping. So that's the big picture category that is being prohibited. And then it says, including certain enumerated concepts, and then, the ones you just listed off there are two of the examples in the sort of list of sort of prohibited concepts. So why is this a free speech issue? It's a free speech issue in part because when we think largely about free speech in our society, we have institutions that are designed to further broad ideas about free speech. And two of the big ones are our K-12 schools and the universities. And so anything really that implicates the content of discussion in classrooms is going to implicate our conception of free speech.
And we'll get to the distinction between K-12 schools and universities in a minute. But first, Steph, specifically in the setting of higher education, you are a part of a group called UW Profs that represents faculty in front of legislative bodies and the Board of Regents. So why does your group take issue with this legislation banning the discussion of race and sex on college campuses in this way?
Well, Profs represents the UW faculty members, and one of the things that we represent is the academic freedom of various professors throughout the university system. There are certain threats to academic freedom posed by these bills in that the bills are structured, seems fine in general, but they could have a chilling effect on discussions, right? So the concern is that one might be talking about the history of the United States, and that might lead to students feeling bad, right, about their particular kind of histories. Now, that would not necessarily be the intent of the professor, but the mere fact that a student might feel bad might mean that they could raise a lawsuit against the university, and thus overall it creates a chilling effect on what faculty members might feel free to say. For example, I might talk in my food law class about the history of discrimination by the USDA, and this was acknowledged by the USDA in a lawsuit, which it settled, against Black farmers. They had had a whole history of actual intentional discrimination that, again, the USDA acknowledged. This might lead students to feel bad, for example, about this particular history. And would this fall over the line of this bill? It's hard to know. And it might lead to sort of frivolous, potentially lawsuits, but still lawsuits that it would create a chilling effect. Moreover, there has an effect on the recruitment of both faculty members and also graduate students who might, especially those who will have to teach in classrooms, they might be concerned about being able to engage in the kinds of teaching that they want to be able to do because, again, of the chilling effect. And that means that we're going to have to recruit as a university system from a smaller pool of faculty and thus lead us to be less competitive as a university.
And that's interesting that you bring up even just teaching about the history. So it could have the chilling effect and stifle instructors' ability to teach about the United States history, which includes discrimination. Anuj, is there a difference between prohibiting this in K-12 schools versus in a higher education university setting?
Yes. So the short answer is absolutely yes. I do, before I answer it directly, I just do want to, pick up on one theme that that Professor Tai raised, and that is this question of what we, First Amendment lawyers refer to as the chilling effect. There are certain things that the law might prohibit that we actually might all agree it ought to prohibit people from saying, whether in K-12 or in universities. And, as Professor Tai pointed out, the big question here, I think, is, what, again, lawyers call an interpretive question. What exactly is meant? And, as she was indicating, the question about whether or not certain discussions might fall into the statute. I think if we, step back for a second, I think, overall, if you look at the way the legislation has come through, you could, if you were inclined, accuse those who have introduced it of trying to do just that, that is suppress discussion about race in general. But if we take those legislators at their word, we can imagine a sort of narrower interpretation that sort of goes back to sort of where you started us with the bill, and that it's prohibiting things like, teaching that one race is inherently superior to another race, right? And those are things that, if thought of in, in their literal way, seem unobjectionable. Right. And so I think one thing to be thinking about in this whole discussion is how much of a chill are laws like this actually going to have. So let me go now to your, directly to your question about K-12 versus colleges. So the short answer is in the K-12 context, the government has almost sort of complete discretion to set the terms of education under the First Amendment. There are some limits, and so one that might be relevant here is, the courts have indicated that if education curriculum is done in a nakedly partisan way, that might violate the First Amendment. But the courts have never found this. Okay, so they've sort of indicated that this would be the case, but have never actually held something to be nakedly partisan. Whereas, as Professor Tai was mentioning, in the college, college and university perspective, areas, teachers have just a lot more leeway, I guess is what I would say, to express their own views about things, and that is that concept of academic freedom, which intertwines with freedom of speech, and is part and parcel of it in constitutional law.
And Steph, there is a long list of words and phrases listed in an addendum to this legislation that was authored by Representative Wickers. And he adds that prohibiting certain words like social justice, equity, anti-racism, restorative practices, woke, racial prejudice, intersectionality, just to name a few, but it's a very, very long list. If those words are used in the context of this legislation, those would also be prohibited. What's your reaction to that?
Well, this actually goes to something that Professor Desai mentioned, which is that this is all going to be up to the interpretation of courts. And the effect of this is going to be that even though it's not in the legislation itself, it is an interpretive tool. So one of the rules of statutory interpretation is that some of the legislative debate and author's intent goes into the interpretation of that. And so while not actually in the statute itself, these words would be used by judges to figure out the scope of the bill, right? Whether it's interpreted broadly to include many different types of things, thus covering a larger set of things, versus interpreted narrowly. I do want to go back to one thing that Professor Desai mentioned, is that while courts have not held that that rejected a bill that limited the scope of curriculum due to entirely partisan reasons, there was a case in Arizona where Gonzales v. Douglas, where a federal judge did overturn a ban on ethnic studies in Arizona, reaching from K to 12 to colleges, because it was based on racial animus, and they found that in some of the legislative history. So there's small exceptions, and a lot of this is going to depend on what the legislators say, what they do, all of this kind of interpretational stuff.
And Professor Desai, there are already some lawsuits about this legislation pending. Can you describe what you know about those lawsuits?
Sure, yeah. So let me back up. So this is right now in Wisconsin, at least, these are just bills. So they are not laws, and so there are no lawsuits about them because they are not the law. And maybe we'll talk about this later. It doesn't seem highly likely that they will become the law, because I think the governor, also as a former superintendent of public instruction here, has effectively indicated that he will veto them if they come before him. But there are a lot of similar laws that other states have passed at this point. And so some of those laws have been challenged. One in Oklahoma I know of, one in New Hampshire I know of. There may be others. I'm afraid I'm not up on all the latest, but there are probably about a dozen other states that have passed laws that are similar to this. So I will say one thing that I'm not 100% sure the lawsuits have done, but may be contributing to. I mean, one thing that has happened since these bills were introduced, and you referred earlier to that list of words that was attached, initially back in July or August of 2021. But since then, there have been amendments, and the amendments have, passed in the committee. And those amendments really have narrowed the Wisconsin bills kind of significantly compared with a bunch of the other states that have passed legislation. So, you can think, for those of us who care about the kind of legislative and broader legal process, you can think of this all as part of kind of national discussions that, that we as a country are having about, the role of K-12 schools and colleges in kind of race-related education.
And Professor Tai, along those lines, I mean, what do you think that these bills are actually saying? They're largely, as Professor Desai just said, part of this kind of big political movement, and there's some conservatives saying that there's now reverse discrimination happening, and it's getting twisted. They're trying to ban critical race theory specifically, something that's not even taught in K-12 schools. What is your reaction to kind of all of this discourse swirling around that's now creating real proposed legislation?
I think part of it is just, I don't want to use as harsh a word as this, but fear mongering, right? It's using some kind of specter to raise, to drive out votes in particular directions. Again, I use this word fear mongering, even though right now there should be a better word for this, because critical race theory is not being taught in K through 12. It's not even being taught in colleges. It's kind of being taught as a very thin slice of law school, but that's it. It's not an actual thing that people are teaching, although in the proposed bill, they were talking about this as a sort of generalized term. It's actually a very specific term that has a concrete legal history. And so I think that's where some of this is coming from. Another part of this is also potential for lawsuits. So there are organizations that get sizable attorney's fees from suits like this, because this bill, even though it's not passed yet, this bill would grant attorney's fees for anyone representing complainants about this, about teaching. And the complainants are not limited to those who are in the class. They are any student or staff member of a university. So this provides a broad pool of potential claimants who might be able to get attorney representation by attorneys that want to seek attorney's fees in some way. What this means, though, is that this is actually a hidden tax on Wisconsin voters. The taxes are not paid out of the university system or the K through 12 system. They're paid by us with our income taxes. And so this is a hidden part of the agenda, I think, that is not really discussed very much.
And this last question is for both of you, and Professor Desai, I'll ask you first. Even if the Assembly and the Senate pass this legislation, which is likely, it'll be sent to the governor's desk, and as you already mentioned, he's likely to veto it altogether. So what does this type of legislation implicate, even if it won't be signed into law?
Yeah, it's a great question. I think it implicates broadly political discourse, right? I mean, as Professor Tai was mentioning, these are issues that people really care about, and all across the political spectrum, right? People really, really care about, and as Professor Tai pointed out, people vote on the basis of these things. And so just because a bill doesn't pass doesn't mean it doesn't have a political impact. If you don't mind, I will sort of, respectfully, kind of disagree slightly with what Professor Tai had said earlier. I don't think the proponents of these bills, and by the way, none of our bills, at least, use the term critical race theory in the legislation itself, right? I don't think it matters too much a thing that is officially critical race theory is taught in the schools. I mean, I think what they're concerned about is, that list of things, that somebody is being taught that, because of their race, they are responsible for things in the past that people of their race did, or things of that ilk. So, I guess I have a slight, disagreement there. And, just on the question of the attorney's fees, it's important to realize you only get attorney's fees if you're successful, right? You don't get attorney's fees if you lose the case. Now, it is true that there is always the worry that people will be incentivized to bring cases. But that's a system we set up for lots of things. I mean, environmental claims, we have attorney's fees for. There are lots of circumstances where the law says we want to encourage people to help enforce the law because otherwise it's not likely to be enforced as well. So, but I'll leave you with that.
Professor Tai, you did.
Sorry.
Go ahead. I mean, you did say that in regards to what Professor Desai was saying about the fact that even just teaching history might show that I'm responsible for the actions of my ancestors in American history, and you did mention earlier that could include a student feeling bad, and then that could fall under the purview of this legislation. But do you have a reaction to that? And what do you say the implications of even just introducing this legislation is?
Well, I think the implication is to, if it passes, but even the introduction of it has already created some cause of concern among faculty members, especially in terms of recruitment of faculty members, because they're going to be here for a very long time. And even if the bill doesn't get passed now, who's to say that after a gubernatorial election, the bill wouldn't get passed in some future? And so people are making very long-term decisions that they might be more hesitant to make if they had an option to go to a different university in a different state. So there's that kind of concern. I do want to go back and say that I wasn't suggesting that critical race theory is not being taught in K-12 and that's why it doesn't matter. My suggestion is mostly that critical race theory is used as a shorthand for a very large number of things that are not actually specifically defined. Therefore, they're more able to use this as this sort of generalized specter that can sort of shapeshift at whatever moments. And as for attorney's fees, the only reason why I mentioned that is that there is a particular organization in Wisconsin who has announced their mission to challenge critical race theory. And this is specifically, they wouldn't have been able to get attorney's fees before that, and they now would be able to if this bill were to pass. And so that organization, my understanding is that they contributed to this legislation. So there's a particular kind of self-interest that's involved. Again, there are attorney's fees for so many other things, but this seems driven by a particular organization.
A very complex issue that I'm sure we'll be covering if there's any more action on this legislation. But in the meantime, Professor Steph Tai and Professor Anuj Desai, thank you both very, very much for the conversation today.
Thank you. And thanks, Professor Tai, too.
Yeah, thanks, Professor Desai.
For more from Here and Now in PBS Wisconsin, you can visit pbswisconsin.org. And thank you so much for joining us on Noon Wednesday.